number 118723 in the matter of John Bernard Sullivan.
May it please the court. Matt Vogelsberg with the Office of Disciplinary Administrator. Mr. Chief Justice, I'd like to reserve 2 minutes for rebuttal.
2 minutes is granted.
Thank you. This is an original proceeding in attorney discipline involving John Sullivan. Mr. Sullivan was admitted to the bar in 2004. Based on a joint motion filed by the parties in this action, this court issued an order on February 10th, 2014, temporarily suspending Mr. Sullivan's law license. His license has remained suspended since that time. This matter, now before the court, involves 6 separate complaints that were heard by a panel on July 11, 2017. The first complaint, docketed as DA 11754, concerns Mr. Sullivan's conduct before the 10th Circuit Court of Appeals. After filing a notice of appeal on behalf of his client, Mr. Sullivan failed to take any further actions to move the appeal forward. This was despite receiving multiple notices from the clerk of the 10th Circuit. Ultimately, in January 2013, the 10th Circuit indefinitely suspended Mr. Sullivan from practicing law before that court. A copy of the court's order was forwarded to the Disciplinary Administrator's Office in late January 2013. The second complaint, docketed as DA 12005, was filed by DP, a former client of Mr. Sullivan's. In that case, DP hired Mr. Sullivan and provided him an advance of $750 to represent him in a probation violation case pending in Sedgwick County. Mr. Sullivan ultimately performed approximately 2.9 hours of work, billed at a rate of $150 per hour. In August of 2013, DP informed Mr. Sullivan that his services were no longer needed and requested a refund. DP made subsequent requests for a refund that Mr. Sullivan ultimately ignored. DP filed a complaint with our office in January 2014. Mr. Sullivan provided a response to that complaint. In April 2014, Mr. Sullivan provided a refund to DP of $315. The next complaint that I'd like to discuss is DA 12014, and this complaint concerns Mr. Sullivan's involvement in 4 criminal acts that occurred between December of 2013 and November of 2015. On December 11, 2013, Mr. Sullivan was arrested in Clark County, Kansas, for possession of methamphetamine, possession of marijuana, possession of drug paraphernalia, driving while suspended as a second offense, no proof of liability insurance, and speeding. Ultimately, Mr. Sullivan pled to misdemeanor charges of possession of marijuana and possession of drug paraphernalia and 1 count of speeding. Respondent received a suspended 12-month jail sentence and was placed on probation. At the formal hearing, Mr. Sullivan presented evidence showing that he had been discharged from probation in Clark County. A couple weeks after being arrested in Clark County, Mr. Sullivan was arrested on January 1st, 2014 in Sumner County, Kansas for possession of methamphetamine and possession of drug paraphernalia. He ultimately resolved these charges by pleading guilty to a misdemeanor charge of possession of drug paraphernalia. Mr. Sullivan was given a 6-month suspended jail sentence and placed on probation. At the formal hearing, Mr. Sullivan presented evidence showing that he had been discharged from probation in Sumner County. On April 26, 2014, Mr. Sullivan was arrested in Sedgwick County for possession of methamphetamine and possession of drug paraphernalia and driving while suspended. These charges were ultimately resolved by Mr. Sullivan agreeing to enter guilty pleas to 3 counts of misdemeanor possession of drug paraphernalia, and the respondent was placed on probation for 3 years. Finally, on November 4th of 2015, respondent was arrested in Cook County, Texas for possessing MDMA, possession of heroin, and possession of methamphetamine. Subsequently, a grand jury indicted him for these crimes, and ultimately, on January 11th, 2017, the District Court of Cook County, Texas entered 2 orders of deferred adjudication following Mr. Sullivan's guilty pleas for possession of heroin and possession of methamphetamine. In exchange, the remaining charge of possession of MDMA was dismissed, and Mr. Sullivan was placed on community supervision for 7 years. The final 3 complaints, DA 12034, DA 12080, and DA 12131, concerned clients whose criminal cases were pending when criminal charges were filed in Clark and Sumner counties against Mr. Sullivan. As a result of Mr. Sullivan's own criminal matters and the temporary suspension of his law license, these clients' cases were delayed until new counsel could be appointed. The 6 complaints against Mr. Sullivan again proceeded to a formal hearing that was conducted on July 11, 2017. Mr. Sullivan appeared in person and was represented by counsel. At the start of the hearing, the parties noted that there were no factual disputes, and counsel for Mr. Sullivan noted that they were not contesting the rule violations alleged in the formal complaint. Accordingly, the hearing panel found violations of Rule 1.1, 1.3, 1.4a, 1.8f, 1.16a2, 1.16d, 8.4b, 8.4d, Rule 203c1, which requires an attorney charged with a felony offense to report the charges to the disciplinary administrator within 14 days, and Rule 211b, failing to file a timely answer to the formal complaint. With regard to the recommended sanction, the disciplinary administrator's office recommended that Mr. Sullivan be disbarred. In the alternative, we recommended that the hearing panel determine that suspension was appropriate, and we recommended that respondent's license to practice law be indefinitely suspended. Mr. Sullivan, at the hearing, requested that his license remain suspended and that he have the opportunity to petition the court for reinstatement in the future. The hearing panel ultimately recommended indefinite suspension. In paragraph 138 of its hearing report, it made several recommendations of factors that Mr. Sullivan should be required to establish by clear and convincing evidence at his reinstatement hearing. Among the factors, the hearing panel recommended that Mr. Sullivan be required to show that he has returned all unearned fees, reimbursed the Client Protection Fund for any claims paid out on his behalf, and that he's been discharged from criminal probation in all jurisdictions. After the hearing panel issued its final report, Mr. Sullivan filed a notice that he was not taking any exceptions to the findings of fact or conclusions contained in the report. And furthermore, Mr. Sullivan noted that he agreed with the recommendation of the panel. At this time, the disciplinary administrator's office recommends that the court adopt the hearing panel's recommendation and impose indefinite suspension. We also recommend that at Mr. Sullivan's reinstatement hearing, he be required to establish all the factors noted in paragraph 138 of the hearing panel report, particularly that he has fully refunded any unearned legal fees, that he has reimbursed the Client Protection Fund for any claims paid out as a result of his conduct, and that he no longer is on criminal probation in any jurisdiction. Now, I would like to explain why we are recommending indefinite suspension now rather than disbarment. I believe the applicable ABA standard is standard 5.12. That standard states that suspension is generally appropriate when a lawyer knowingly engages in criminal conduct which does not contain the elements listed in standard 5.11 and that seriously adversely reflects on a lawyer's fitness to practice. If you look at standard 5.11, the type of criminal conduct described in that standard was not committed by Mr. Sullivan in this case. His crimes did not include the sale, distribution, or importation of controlled substances. Rather, his crimes indicate that he was possessing drugs for his personal use. Accordingly, I believe standard 5.12 is applicable standard and indicates that suspension is appropriate. Because of the repeated instances of criminal conduct, however, I believe the term of suspension should be indefinite.
Counselor, do we know the numbers, the amount of fees that need to be refunded? Are those in dispute?
They are not.
So do we have numbers for that and numbers for client protection?
We do. In DA 12080, RB was the complainant and he was a third-party payer. He provided Mr. Sullivan $2,500 to represent NW. Ultimately, Mr. Sullivan agrees that he owes RB a refund of $2,140. And then in DA 12131, BF and CH collectively paid Mr. Sullivan $2,200, and Mr. Sullivan acknowledges that he owes a refund of $1,810, and it appears that the CPF fund may have paid out a claim to BF and CH in that amount.
Counsel, you referenced the panel's paragraph number 138. Just so I'm clear, are you recommending that the court impose those conditions as a condition of the indefinite suspension?
At the reinstatement hearing, that he would have, when he goes to the reinstatement hearing, he would have to show those things that that restitution has been made, any claim that has been paid out by the CPF fund, that fund has been reimbursed, and also that he would have to make a showing at his reinstatement hearing that he is no longer on criminal probation in any jurisdiction. That would be in addition to the factors that he has to establish by clear and convincing evidence under Rule 219D.
Which would be that he's obtained a level of rehabilitation such that recurrence of the misconduct is unlikely,
Correct.
and he's participated in mental health treatment as directed by the treatment professionals?
Correct.
All right, very good. Thank you.
Counsel, how did your office become aware of the criminal charges and the criminal cases?
Mr. Sullivan, through counsel, reported that to our office in mid-January
Okay.
of 2014.
Maybe I misheard. I heard you recite one of the rule violations as failure to report being
didn't
charged
report.
with a felony.
You're correct, Justice.
So it was just a late reporting?
It was a late
to
reporting. He didn't do it within the 20 days, or
But you're...
maybe 14 days.
No, I guess let me ask it this way. Aside from that, the technical violation of that rule, is it your... It sounds like it's your position here today that you're not asserting that that delayed reporting reflects a character of dishonesty or cover-up or anything like that. Is that a fair assessment?
That's a fair assessment. Now, I'd also like to point out to a couple of factors I believe weigh in favor of imposing indefinite suspension rather than disbarment. When I read through the transcript of Mr. Sullivan's testimony at the hearing, I was taken aback by his candor regarding his drug use. He fully acknowledged that he was in possession of methamphetamine during the incidents in Clark, Sumner, and Sedgwick counties. He did not try to minimize his conduct. He also acknowledged that he was very fortunate to be able to enter pleas to misdemeanor drug offenses rather than felony offenses. And the second factor that I believe weighs in favor of indefinite suspension is Mr. Sullivan's recent efforts to maintain and continue his sobriety. Mr. Sullivan presented, Mr. Sullivan presented evidence that he participated in an inpatient drug treatment facility located in Smithville, Texas. He was admitted to this program on January 2nd, 2016, and he was successfully discharged on April 5th of that year. He then became a resident at Sober Living Residence in Austin, Texas, and because of his success with that program, he became a house manager at the residence on June 1st, 2016. Mr. Sullivan testified at the hearing that he had been sober since January 3rd of 2016, meaning at the time of the panel hearing on July 11th, 2017, he had experienced approximately a year and a half of sobriety. Prior to today's arguments, I spoke to counsel for Mr. Sullivan, who confirmed to me that Mr. Sullivan has continued his sobriety, and so he has now experienced over 2 years of continuous sobriety. I trust what counsel has told me, but I also believe in verification, and so in preparation for today's hearing, I also spoke with the probation officer in Cook County, Texas, and that officer confirmed to me as of last Friday that Mr. Sullivan has been and remains in compliance with the terms of his probation conditions. The officer noted that Mr. Sullivan's probation has been transferred to Travis County, which is the county where Austin is located, and that officer there confirmed that Mr. Sullivan is 100% in compliance with his probation. Also, last Friday, I received a journal entry from Sedgwick County showing that on that same day, April 27th, Mr. Sullivan was granted an early discharge from his probation. And so I believe that this information verifies that Mr. Sullivan continues to stay sober and continues to abide by the conditions of his probation down in Texas. In conclusion, based on Mr. Sullivan's candor at the disciplinary hearing, his continuing compliance with the conditions of his community supervision in Texas, and his continuing efforts to maintain his sobriety, I recommend that this court impose indefinite suspension.
What do you want for the suspension begins date? We have a requirement on indefinite suspension that reinstatement cannot occur before 3 years.
Correct.
Are you asking that we begin that clock upon filing of the opinion or upon the temporary suspension?
I'm recommending that it begin upon the filing of the opinion in this case. I would be in favor of retroactive application if, on the date that the temporary suspension went into effect on February 10th, 2014, we saw an end to the criminal conduct and immediate improvement. But since the last criminal conduct occurred in November 2015, I think running the indefinite suspension from the time that this court issues its opinion in this case would be proper.
Any further questions? Thank you, counsel.
Thank you.
May it please the court, Chief Justice, all other justices. My name is Michael Stedman. I'm representing the respondent, John Sullivan, and I am just going to mention a few things that I think are not in the panel's report. I got to meet John Sullivan for the first time. This was back in early 2013. And this is when our local committee was contacted that Mr. Sullivan had an accident and he was in the hospital. And I went with another committee member, Chris Garcia, and John had ran into a tree and he broke his neck. Barely, the surgeon thought he should be paralyzed. He escaped that. This was an obvious suicide attempt. His family was there, we talked, I made recommendations, and he was placed in a treatment facility that would actually take him with his broken neck. And so he attended and completed at Father Martin's facility on the East Coast, his first treatment. Now, later in that year, other things occurred, and we had these arrests. And as soon as we heard about them, I entered on those cases and I assisted Mr. Sullivan with these criminal cases. We did what was necessary in informing the court, informing his clients, agreeing to certain things. Mr. Sullivan understands that his addiction is no excuse, that his clients were injured by this conduct. And it was a profound injury. He also understands, I think now, his disease better. He understands that he's an addict. He understands his addiction does not go away. And he has been successful now for a little over 2 years on a daily basis through a 12-step program in maintaining his sobriety. He is located in a community that has a very strong sobriety. Their culture there is profoundly powerful. I'm well aware of Austin as I came from that region growing up. Now, Mr. Sullivan completed 2 more inpatient stays while he was dealing with these cases. And the last one, I think, was in Smithsville, Texas. It was called The Last Chance, and this was a long 90-day program. And he was able to, I think for the first time, work the 12 steps. This was after the arrest that he had in Texas, where not only did he have methamphetamine in possession, but now it was heroin. And I don't know what it was that convinced him, but I think he genuinely got into his heart the 12 steps and started working the program. And I think he showed that he could be very successful. And he has been. And he needed to be. Most of us that were closer to John, and this included a lot of people in Sedgwick County, the one thing that I found different in this case than other lawyers that I have represented is that when I told them about John, even the clients that were at that time in the detention facility, they showed more concern about his condition than their own. which I have never seen before to this extent. We also, my office took over all of his cases until we could get service to the bar, which is another local committee in Sedgwick County, to take over. And they were able to take over, and they did a remarkable job. This was handled by all volunteers in Sedgwick County, took care of all these cases. And Mr. Sullivan had a great deal of open criminal cases. And these were difficult cases. These were not simple felonies. These were some of the more extreme. We also received assistance from the Oklahoma Bar, from their LAP program, which I made contact because he was licensed to practice in Oklahoma, and thereby he had a couple of cases that their volunteers helped. So John has had a lot of help from our local bar association. I think he has gotten some breaks, some remarkable dealings in court in not having to plead to a felony. And I believe today John is, he works hard at his job. He is, as a non-legal job, but he is making sobriety his #1 mission. John also, though, upon the closing of his practice, I know a lot of his behavior because I was there from day one. His paralegal came to my office and I hired her, and we worked all of these cases. In fact, we had quite a few different people investigating just from our local ethics committee in Sedgwick County. And either we made the necessary restitution or we had a check in hand. I had the money in my trust account waiting to pay whoever they would tell us. We still have a couple of where we have requested, and I am hoping that we get that taken care of prior to any reinstatement hearing, because the damage has been done and we are ready and prepared to pay that, and have been in the past. I believe in terms of when we start the counting of the clock, if this court agrees with the indefinite suspension, my client will accept whatever that is. He understands, and he comes with humility today, that he caused a great deal of people a lot of harm.
Counsel, let's
Yes.
talk about starting the clock on
Yes.
this thing. I thought the disciplinary administrator had a pretty good rationale for why we would start the clock on the filing of the order. And sometimes this is a point of contention between the parties. So I just want to make sure that you don't have anything you want to dispute about his rationale for why we do that.
No, his rationale was completely logical. I think throughout, and we've worked with several of the attorneys from the disciplines office, and I think with each attorney, we've had a good working relationship. Mr. Sullivan realizes and has realized, even when he wasn't working what I thought the program properly and didn't quite get it, he was still very concerned, and he was taking action with his clients, and we made sure that he did things appropriately, but there was just a great deal of support. I know there was a great deal of support on Friday. My brother handled that hearing where they were able to end his probation early when Judge Dahl in Sedgwick County ordered that. He has an obligation in Cook County, and he needs to complete that, and he needs to show that he's growing in his sobriety. He needs to have a reinstatement hearing at the appropriate time and present meaningful evidence that he is rehabilitated, that he will not cause harm, and that he will be a benefit. But I did find it very touching in the recommendation by the panel that he worked with lawyers, as I do believe Mr. Sullivan, if he does get reinstated at some point, would be of a great benefit to a LAP program because he understands the disease. And despite his actions, he should be dead, but he is alive today. And I think he can be a very valuable resource. And I believe this is an attorney that should not be disbarred, but should be allowed reinstatement at the appropriate time. That's all I have.
Counsel, does your client wish to address us also?
Yes, Chief Justice, we would like an opportunity for that.
Very well, thank you.
Thank you, sir.
Thank you, Your Honors. First of all, if any of you all have any questions for me, I'd be happy to answer them. As far as what I'd like to say, on the one hand, I've got a tremendous amount of regret for my behavior. I harmed a lot of people, my family, other people that care about me, my clients, the profession, and that's something I live with. But more than the regret, I've got gratitude for all of it. I feel better internally today than I think I ever have in my life, even before the addiction really took off and all of that. Today I understand that I guess being good is infinitely more important than looking good. I've learned some tools to align myself with something higher than my own egoistic kind of graspings, and my life is pretty beautiful these days, and I'm really enjoying it. One of the things I got to see through this whole process is the importance and the beauty of people not giving up on me when I'd pretty much totally given up on myself. Again, my family, Mr. Studman, KLAP, and out of everything that I read in the opinion from the disciplinary hearing back in July, that was the thing that struck me as that was the best thing wherever they recommended that I work, hopefully one day work with lawyers that maybe have had similar issues. Because I can tell Your Honors that now, after being sober for a little while, that's pretty much the greatest benefit. That's the biggest joy of all of it, is getting to work with people that are going through similar things and trying to help them get through it. And whether that's in the context of the legal community, or just people I meet in the rooms of Alcoholics Anonymous and so forth, that's something I'm going to keep doing. So that's really all I have. So thank you.
Do we have any more questions? All right. Thank you, counsel.
Thank you.
Reserve 2 minutes for rebuttal.
Unless the court has any questions for me, I would waive rebuttal.
I have one. I just noticed that, reminded me that he was disbarred March 1st, 2016 in Oklahoma. Does he have any outstanding financial obligations in that state that you know of?
Not that I'm aware of.
Okay.
And I'd also just add that I believe his disbarment in Oklahoma was a result of not participating in the disciplinary proceedings in Oklahoma.
Any further questions? I see none. Thank you, counsel. We thank all of you for your arguments this morning and this afternoon. Court will take this matter under advisement.